know as I got closer and closer to the courthouse, the rain started coming in harder and harder. It started lightning. I was running. Hey, if anyone saw me, I was like, no, because I was like, I had 10 minutes to. Oh my gosh, how many people are here? Do what? Tyrell Leonard.
He's in the jail, Your Honor.
Okay. Leslie, you ready?
Yes, thank you.
Okay. All right. We will go on the record in cause numbers D40147, D40149, and D40274, all style State versus Tyrell Leonard. I have counsel for both sides present. Defendant is present. And these are motions to withdraw. Is that correct?
That is correct, Your Honor.
Okay. And you may proceed.
Yes, Your Honor. I am here today asking for permission to withdraw from this case. Mr. Leonard and I have been on his cases for almost, I think, a year or right over a year. And the last time I saw him, he asked if I could be removed so that he could hire someone. And I'm not sure if he has been able to do that or if he would need someone else appointed.
Okay. Well, Ms. Schumer, any objection?
No, Your Honor, I would just request that we try to figure out quickly if he's incarcerated, how he might be able to hire someone, and if not, appointing someone as soon as possible.
Okay. Let me take care of the motions first. The motions to withdraw on each of these are granted. Mr. Leonard, are you going to hire an attorney?
He's muted, Your Honor.
Yeah. Sir, you'll have to unmute yourself.
Sir.
Yes, sir. Are you going to hire an attorney?
Yes, sir.
Okay, so, all right. Do you have a time frame of when that'll occur?
I'm gonna get in contact with my parents and I'm gonna see, and then I go from there. If they don't get one hired in time, I just get appointed a lawyer.
Okay. You understand that we're on a scheduling order, so sooner rather than later.
Yes, sir.
You
And
changed your
Judge-
mind, sir.
Hold
You
on,
need to-
Your Honor, just to clarify, on these three cases, we have been through the scheduling order and they are waiting for trial. They've kind of been in the waiting pattern for when jury trials and trial confirmations on these
Thank you.
three. He does have two other new pending ones that Mr. Perkins represents him on, and I believe he also has motions to withdraw in those cases. Mr. Leonard also wanted him to be off his cases.
Okay.
Yes, Judge, and I'm here too.
Are you on these cases too?
He is on the 739 and 741. Those are the ones Mr. Perkins is on.
Those are not before you today, Your Honor.
Gotcha.
Mr. Tyrell Leonard has 5 pending cases at least.
Gotcha. Okay.
And I've filed a motion to withdraw also, Judge.
Okay. Probably if I haven't heard from Mr. Leonard and or from someone representing them. We'll set it for a status in the next less than 30 days. All right.
Thank you, Your Honor.
And assuming were there orders attached with the motions?
I did e-file them this morning, Your Honor, as instructed by the clerk.
Gotcha. I will look for them. I'll sign them when I get to them.
Thank you, Your Honor.
That concludes these 3 hearings. Thank you.
Good luck, Mr. Leonard.
Wesley Bunch.
Judge, that's my case also.
Gotcha. These are both motions to reduce bond. Is that correct?
Yes, Judge, I've filed motions to reduce bond in each case and a motion for a speedy trial also, Judge.
Okay. Are those both set for today, the speedy trial and the?
I'm not sure, Judge.
It looks like, Your Honor, on the speedy trial one, you signed it, but you didn't put a date in there for the hearing.
Okay.
And that may be why it didn't show up today.
All right, Melissa, do you know if that's been set for today or is that set for another day?
Was it all in one filing, John?
I don't remember if we filed them. They would have been filed on the same day, but I'm not sure if they were in the same actual filing.
Both orders were signed on 5/4. And on the motion for bond, you put a date in for or somebody put a date in for 5/11. However, there was not a date on the speedy trial one, but it was signed on 5/4.
Then that would be my mistake because I should have put the date in.
Okay. Is the state prepared to go on that motion for speedy trial?
Your Honor, we don't have any objection to a speedy trial, but the defense, we have a couple of 100 pages worth of CPS records and some other stuff that the defense will probably need to come look at.
Okay.
Judge,
I
we
mean,
also.
Do you have any, but are you going to have any objection to hearing the speedy trial motion today?
No, Your Honor.
Okay. Well, we'll do them both then so we can go ahead. All right, let's go on the record in D40450 and D40452, both style State versus Wesley Allen Bunch. I have counsel for both sides present. Mr. Bunch is present, and let's go ahead and do the motion to reduce bond in each of these cases. And just so I'm clear, bond, both of these cases are well, D40450 is aggravated sexual assault of a child. The other cause number is indecency of the child.
Your Honor, the aggravated sexual assault is $250,000 and the indecency is $50,000.
Okay. And those both appear to be cash bonds, if I'm not mistaken, according to the magistration.
On the jail record, Your Honor, Sherry Schumer, I apologize. On the jail record, 452 indecency shows a surety bond, and the aggravated sexual assault 450 shows a cash bond.
Okay.
I don't know if that's different on your paperwork than what's on the jail record.
Well, let's go ahead and court will take testimony or evidence of some sort. Mr. Perkins, I'll turn it over to you, sir.
Thank you, Judge. And I would call my client, Mr. Wesley Bunch.
Is this for the limited purposes of bond?
Absolutely, Judge.
Gotcha. Mr. Bunch, if you could raise your right hand, sir. Do you swear or affirm the testimony that you give in this case will be the truth, the whole truth, nothing but the truth, so help you God?
Yes, sir.
All right, you may proceed.
Mr. Bunch, can you state your name for the record?
Wesley Allen Bunch.
And you are the defendant in the two cause numbers, correct?
Yes, sir.
And you are currently incarcerated in the Navarro County Jail, is that correct?
Yes, sir.
Okay. And how long, when were you arrested?
I believe August 11th of 2020. I believe it's,
Okay. So you've been in jail for 9 or 10 months, right?
yes, sir.
Okay. And have you been able, you understand you have a $250,000 bond in one cause and a $50,000 bond in the other cause, correct?
Yes, sir.
Have you been able to make those bonds?
No, sir. One was cash bond. And I mean, honestly, if I had $250,000 lying around,
I
wouldn't be here.
understood. Yeah, wouldn't we all? Exactly. So let me ask you this. If the judge was to reduce your bond, where would you be living?
I'd be living at my grandmother's house where I was arrested from.
Okay. And does the alleged victim live at that location?
No, sir.
Okay. And do any young children live at that location?
No, they don't.
Okay. And if you were able to bond out, would you be able to get a job?
Yes.
Okay. And you said your grandmother's house. What's that address? Is that here in Navarro County?
No, it's 1965 Highway 90, Madisonville, Texas.
Okay. And so that's down south. It's not in Navarro County, correct?
No, it's not. I don't have any family.
Okay. Okay. And if the judge was to set bond at a bond you could make, would you promise that you would return for all court settings?
Definitely. I will be here.
Okay. And in fact, we've also filed a motion for a speedy trial on this, correct?
Yes, sir.
Okay. And so back to a question you may have answered already. Would you be able to get a job?
Yes, sir. I can. I've never had a problem working.
Okay. And would you be able to help support yourself, support your family, that sort of stuff?
Yes. Yes, sir.
And would you be agreeable to any conditions of bond that the court might consider reasonable, including possibly a GPS monitor to ensure that you're not having any contact with young children?
Yes, sir.
Okay. And are you asking that the court set these bonds in an amount that you could possibly make?
Yes, sir. Something pretty reasonable. I mean,
okay. And how much do you have any cash or assets that you'd be able to use to put towards this bond?
at 9 months being in here, I pretty much lost everything I've owned. I was the
Okay.
breadwinner for my family, so.
Okay. Now, let me ask you this. You say you have a family. Do you have children?
I do. I have 5 kids. I have
Okay.
4 biological
And-
and 1 stepchild.
Okay. But your living arrangements would be such that you wouldn't have contact with them, correct?
Correct. My wife is actually staying with my mother in Arkansas, so I would not be there.
Okay. And would you be able to help support those children and be able to help take care of them financially if you were able to bond out?
Yes, sir.
Okay. Now back to my original question. Does your family have any means that they could possibly help you make a bond?
Yes, I have several family members who are pulling together and working on coming up with the cash flow to get me out of here.
Okay. So if we were to set a bond in an aggregate, when I say aggregate, I mean the total amount across both cases in the amount of $100,000, do you think you could make that bond?
That's pretty steep. It'd be $10,000 the bond out, and I don't have $10,000.
Okay. What's a realistic bond that you think you could make?
Realistically, $50,000.
Okay, a $50,000 bond. So you're asking the court today to set an aggregate bond of $50,000.
Yes, sir.
And you understand that there would be significant conditions of those bonds, meaning that you'd have no contact direct or indirect with a victim or any of the victim's family in this case, and that you would have no contact with any children under the age of 18 pending trial on this case, correct?
Yes, sir.
Okay. And I know I already asked you this, but just to be clear, and you give your word that you would show up for any and all court settings as they are set.
Yes, sir.
Okay. I would pass the witness, Judge.
Mr. Bunch, you're currently on felony probation, is that true?
Yes, sir, I am.
And there's no bond set on that felony probation revocation warrant, is there?
No, sir, there's not.
Now, you were arrested in Madisonville on this case, is that true?
Yes, sir.
Did you tell your probation officer you went to Madisonville?
I didn't. I was school clothes shopping for my kids,
And when did you go to Madisonville?
and was the weekend before I was arrested. It was the Friday before I was arrested.
So you went to Madisonville right after you were contacted by Detective Frazier?
No, I was in Madisonville when I was contacted by the detective. I actually came back to town and talked to Mr. Crawford about hiring him to represent me, but he was pretty high on his amount.
Pass it, witness.
Nothing further, Judge.
All right. No other witnesses, so I'll turn it over to the state.
We call Sean Frazier.
Oh. Sir, if you want to raise your right hand, do you swear or affirm the testimony that you give in this case will be the truth, the whole truth, nothing but the truth, so help you God?
I do.
All right, you may proceed.
Detective Frazier, state your full name, please,
Detective Michael Sean Frazier,
and where you work.
Corsicana PD.
In that capacity, did you have occasion to investigate Wesley Bunch?
Yes, sir.
What did you investigate him for?
I had a complaint in reference to an aggravated sexual assault of a child, and also a indecency of a child was also discovered during that investigation.
And did you attempt to contact Mr. Bunch
Yes, sir.
prior to obtaining a warrant?
Yes, sir.
Now, did you later obtain a warrant?
Yes, sir, I did.
And was Mr. Bunch living at the address that he had left with probation?
Not that I'm aware of, sir. I had actually attempted to contact and contacted his wife. I was not aware of his exact location at the time of trying to contact him.
And how did you find out he was in Madisonville?
Actually, that came from the child's mother, who passed information to me, and she also contacted Crime Stoppers. And ultimately, Navarro County SO had contacted me in Madisonville, and I think it's Madison County, of a possible location of where he was at.
Now, do you believe the defendant is a danger to persons in Navarro County if he's released?
I believe in his possibility in reference to children.
And do you find that people that tend to molest small 8-year-old children tend to do it repeatedly?
Yes, sir.
Pass the witness.
Detective, did you do any research into my client's criminal history?
Beyond running a criminal history on him and during the investigation?
Yes.
No. I ran a criminal history and observed his past criminal history, but I
Okay.
didn't look further into it.
And you would agree with me that he doesn't have any prior history of molesting 8-year-old children, does he?
Not that's annotated on his criminal history.
Okay, so there wouldn't be any evidence that this is repeated, the alleged behavior is indeed repeated behavior, is there?
Not documented, no, sir.
So that would be pure speculation on your part, wouldn't it?
It's a historical aspect, so I guess you could say yes.
So yes, that is speculation on your part?
In reference to the history of children, yes, sir.
Okay, but you don't have anything that would suggest that my client has history like that.
Nothing documented, no, sir.
Okay, so that's pure speculation on your part, isn't it?
I've answered the only way I know how to answer it.
I'll move on. Detective, when Mr. Bunch was arrested in Madisonville, did he resist arrest or try to flee in any way?
I was not there.
Okay. Did you get any reports of that?
I don't have any reports from them, no, sir.
Okay. Was he charged with resisting or evading?
Not that I'm aware of.
Okay. So he was cooperative, in fact, wasn't he?
I would assume, but I don't have any facts for that.
Okay. And you said that you believe that he has he represents what could be a potential danger to children in the community, correct?
Yes, sir.
And would you also agree with me that the court would be able to put conditions in place that my client's already said he would abide by, where he could have no children or no contact with children?
Not understanding your question. Can you rephrase?
I think I cut out there for a second. I apologize. I said, you understand that if the conditions of bond have can be put in place to ensure that my client has no contact with children, correct?
In reference to conditions, I do believe that they can be in place.
Okay. And in fact, did you hear my client answer in the affirmative when I asked him if he would be willing to comply with any such conditions?
I did hear him say that he would comply.
Okay. And so if he was compliant with those conditions of bond, wouldn't you agree with me that he would pose no threat to children in the community?
I can't stipulate what he's going to do.
Okay. But once again, if he complies with those conditions of bond as set by the court, would you agree with me that he would pose no risk to children?
I would say it's a possibility.
Okay. Pass the witness, Judge.
Okay. Anything further? This witness from the state?
Your Honor, I have a couple of questions. Detective Frazier, Mr. Bunch is currently on probation for assault family violence. Is that true?
Yes, sir.
And that's assault family violence with a prior conviction.
Yes, sir.
So he has been assaulted to his family in ways other than sexual.
Yes, sir.
Pass the witness.
Nothing further, Judge.
Okay. Anything further from the state? Any other
Yes,
witnesses?
Your Honor, we call Janie Stevens.
Okay. Ms. Stevens?
Yes.
Do you want to raise your right hand? Do you swear or affirm the testimony that you give in this case will be the truth, the whole truth, nothing but the truth, so help you God?
I do.
You may proceed.
Ms. Stevens, are you a probation officer? And are you Mr. Bunch's probation officer?
I am.
And is that the same Wesley?
Hold on, Mr. Dickens, hold on one second. Ms. Stevens, you're cutting out, so I heard Leslie trying to get your attention, and I think that's what she was wanting. Can you? I'm not sure if there's a delay or something, but Mr. Dickens, if you don't mind asking your last two questions over again.
Okay. Ms. Stevens, are you a probation officer?
I am.
And are you the probation officer for Wesley Bunch?
Yes.
And is the Wesley Bunch that reports to you, do you see him on the screen in front of you?
I do.
Now, you heard that the testimony that they arrested Mr. Bunch in Madisonville.
Yes.
Did he ever contact you and get permission to go to Madisonville?
No, he didn't.
Now, there is a current motion to revoke his probation filed. Is that true?
True.
There are allegations that he violated his probation in ways other than these offenses. Is that true also?
Yes.
Pass the witness.
No questions, Judge.
All right. Any other witnesses from the state?
State rest, Your Honor.
All right, Mr. Perkins, any rebuttal?
No, Judge.
Okay, I'll take closing.
Judge, we would ask that you heard testimony from Mr. Bunch that he would comply with any conditions that the court might set on a reasonable bond that he could make so that he could obtain release pending a trial in this case. Thank you.
All right. Anything from the state?
Your Honor, the state would assert that, one, the defendant's actions in assaultive offense against family members and the fact that he may have committed these offense proves that he's a danger to people in this county and in Madison County if he were to live there. Would also note that he has probation revocation, which he has no bond on.
All right. I'll take this under advisement. I'd like to consider a ruling. As far as the motions for a speedy trial, the court will take judicial notice of its files, and the court will take judicial notice of the current pandemic and the orders this court and all courts in the state of Texas have been under since last March. And with that, I'll turn it over to Mr. Perkins on the speedy trials.
Yes, Judge. Would call Mr. Bunch, who's been previously sworn.
All right, you may proceed.
Mr. Bunch, you asked me to file a motion for a speedy trial. Is that correct?
Sure, I did.
All right. And you want this case to go to trial as quickly as possible?
Yes, sir, I do.
Okay. And you understand that the state of Texas has been under emergency orders from the Texas Supreme Court that have not allowed trials to go forward for roughly the last 16 months, correct?
Yes, sir, and I'm under the, I've heard that as of April 1st, those stipulations were lifted. Or
as of right now, the court here in Navarro County has not been authorized to hold a jury trial at this point. And are you aware of that?
yes, sir.
Okay. And are you aware that the court has to, in order to hold a trial, that the court has to have a plan put in place that has been approved by the Supreme Court?
Yes, sir.
Okay. And you aware that that process is in process?
Yes, sir.
Okay. And are you asking the court as soon as trials do start back up that this case be given priority?
Yes, sir, I do.
Okay. And is the reason because you are being prejudiced by being incarcerated for an extended period of time on this case?
Yes, sir.
Okay. And do you have any other reasons why you feel you're being prejudiced if you are not granted a speedy trial?
No, sir.
Okay. Would pass the witness, Judge, for the limited purpose of the speedy trial.
Yes.
State has no questions, Your Honor.
All right. The court will
State
also.
state has no objection to the speedy trial motion, although like we said, we have a lot of CPS records that the defense has not looked at yet.
Okay.
Yes, Judge. Go ahead.
I'd like to consider really on the motions for speedy trial, because I know that there's currently in effect a minimum health protocol and in-person schedule hearing that's in effect for this Navarro County and up until June 1st. So, but I'd like to review that again. And yes, you were going to say something.
Judge, I was just going to say that, well, actually, I lost my thought, Judge. I believe I was going to say that we're just asking that this case be given priority, that I will make arrangements for to review those documents with the district attorney's office. I have not been noticed that those documents were available, but I'm taking that as notice today that those documents are available for review. And I assume that those are documents that cannot be turned over to me in discovery. So I will get with the state and review those documents. And the defense also has a pending ex parte motion on an expert.
Gotcha. All right. Anything further?
Nothing from the defense, Judge.
All right. Thank you all. That concludes both these hearings.
Thank you, Judge.
Thank you.
Have a good day.
You
Yes, sir,
too.
you too.
I think
Wofford,
that's
why are you
it,
looking at me?
because I think that's it for us.
I was wondering why you were making me nervous. You were staring at me.
You got my message, Judge?
I did. I mean, it was kind of menacing. I didn't like it. It made me nervous. So I was gonna call, I'm gonna call the police.
I work over here.
All right. I got a peace officer over here to my left. I'm gonna make a report to her. Terroristic looks.
Okay. Y'all have a good day.
All right, you too. Okay, before we go on the record, Mr. How do you say your Gloger?
Gloger, yes, sir.
Gloger. Okay. Like Glover, but with a G and not a V.
Correct.
Okay. All right. We'll go on the record in D36595 and 39455, both style state versus Robert Martinez. And I have counsel for both sides present. Defendant is Mr. Martinez is present. And these were set for contested motions to revoke. And I understand the state filed motions to continue. I'm not sure when they were filed. I know I got the setting request yesterday. So I guess I'll let the state proceed on its motions to continue, and then we'll go from there.
Yes, Your Honor, the state did file those yesterday. The state was preparing for this contested revocation hearing Sunday night. And I realized that some of our dates, there were discrepancies in our dates on the motion to proceed, and absent from the motion to proceed was a violation of bond or protective order. In addition to that, the state is still trying to get a hold of two witnesses, an Irving officer and possibly a loss prevention officer for one of these new offenses that the state wishes to prove up. I did speak with Mr. Keithley, counsel for the defense, who does not oppose this motion to continue, Judge.
That's true.
Okay. And the record can reflect that Mr. Martinez is out on bond, I believe. And so were there terms and conditions of bond that were put in place in addition to the general requirements that he follow all terms and conditions of probation?
Mr. Keithley, do you know the answer to that?
Let me look. I can also look in my file and see if there's anything that. Well, either way, Mr. Martinez, keep reporting to probation as previously ordered when you were placed on probation, okay? I don't see anything in my file, but that doesn't mean that it's not there, but it is now. So there is a witness that's in the jury room. I'm not sure if she was subpoenaed by the state or defense.
That is correct, Your Honor. That is Rebecca Martinez. She is a witness for the state. I would ask, I filed today, I filed the orders to set a hearing. If the court grants the state's motion to continue, I would ask that the state go ahead and put a date on the record, swear the witness in, and order her back to court on that date.
Give me 1 second. Let's recess and we'll try to get I was kind of thinking the same thing too. But I don't do dates and settings. I screw them up. Every time I set a date, it's always on a Sunday at 1:30 in the afternoon. So it never fails.
Yes, sir. So the court would like to recess to.
Yeah, I'm gonna. If Melissa's there, if we got a date.
Sorry, Judge, I was on the phone with Demara. When were they looking for a date?
Well, I'm not real sure a date, sir. Y'all tell me. I mean, as far as, we got one witness here, but you're still looking for two witnesses?
Yes, Your Honor. And, I would ask at least 2 weeks, a week and a half, 2 weeks notice.
Okay.
What about Wednesday, May 26th at 9 o'clock?
That would work for the state.
May I have a moment, Judge?
Yes.
Looks like I'm clear that day.
Okay. We will then come out of recess. And Ms. Martinez, let me go ahead and get you to, can you unmute yourself, ma'am? Tell me your name, ma'am.
Rebecca Martinez.
Rebecca Martinez. I'll go ahead and get you to raise your right hand. I'm assuming Mr. Gloger, that's your witness, as you said, and you want her sworn in?
Yes, Your Honor, please.
All right, ma'am, do you swear or affirm the testimony that you give in this case will be the truth, the whole truth, nothing but the truth, so help you God?
Yes.
Okay. And Ms. Gloger, I'm sorry. I've got too many names on my mind. Ms. Martinez, I'll order you back to the court. You can come to the courthouse. There's nothing that prevents you from coming here, or you can appear via Zoom. But I'm ordering you to appear in this court on May 26th at 9 a.m., okay? I didn't hear you.
Yes, sir.
Okay. All right. And so, so for all parties present, we'll see you back on that date and time.
Thank you, Your Honor.
Thank you very much,
And
Judge.
I'll go ahead and sign those orders here in a moment when I get into my e-file.
Thank you. May we be
Thank you, Your Honor.
excused?
Yes, that concludes both these hearings.
Yes, sir.
Y'all have a good afternoon.
You too,
Thank
Judge.
you.
Thanks, Judge. You too.
Thank you. What I say? 9 a.m.